here with Tom Blackhurst, who's a conveyancing solicitor. He's done quite a bit of work for us, and we felt it would be opportune to get him in and talk about conveyancing and the legal matters around when you buy a property, just to again educate our clients with the importance of having proper legal advice when you purchase a property. Just Tom, maybe as a first question to get the ball rolling, why do you need a solicitor when you're entering into a contract to purchase a property?
Whenever you're signing a contract, whether it's for the purchase of a property or it's a commercial lease or any contract that you are reviewing, obviously you should get legal advice. There's terms and conditions that are important, there's consequences for not meeting your obligations under the contract. And so having a solicitor will not only give you clarity as to what your obligations are, when the due dates are, what the contract says, what you can do in a particular scenario. It allows you to it gives you confidence as you move throughout the process. Without that, you're on your own.
That's a good answer, Tom. And when you said it should be obvious, sometimes things are not obvious. People just don't know what they don't know. So that's even more the reason that you engage a professional to help you in an area that you have no clue about.
I suppose as well, it's a standard contract. So a lot of people think that because it's a pro forma contract that they're able to do it themselves. But at the end of the day, purchasing a home for most people is their largest investment. There's a lot of money on the line, both out of their pocket and in the debts that they're going to be incurring in the way of a mortgage. And so it's important that they've got a professional in their corner, looking after their interests and guiding them through the process so that everything goes as smooth as possible and as stress-free as possible.
And I think the other important point, I think, is also if anything goes wrong, which is very important, that's when you need the expert to actually guide you through that. Because again, as you said, it's probably the most important financial decision you make. And for anything to go wrong, it can cost you a lot of money and time and effort to correct. And that's why, again, you also need the expert.
And stress.
Yeah. And the question that if you're a buyer and the seller tries to do something, just the question, can they do that? Can I stop them from doing that? Am I allowed to do something in return? So it's all these sort of questions that would keep people up at night. Whereas I do these contracts all day, every day, and I can give them an answer within a 2-minute phone call.
So Tom, what's the difference between a conveyancer and a solicitor?
Sure, now this is a really important question. In Queensland, only a solicitor can do conveyancing. But what happens in practice is because it's fixed fee, which we'll go into soon, a lot of solicitors will hire paralegals or their administration assistants. Now what's a paralegal? A paralegal is essentially someone who has no legal training but has worked in a law firm and does simple legal work. And often a lawyer will actually delegate a conveyance to a paralegal or to an admin assistant and call them a conveyancer. But if you're dealing with a conveyancer, it's important to know you're not dealing with a lawyer. You're not dealing with a solicitor. Now, what's the difference? Well, in all honesty, if all things go smoothly and there's no issues, you get your finance easily enough, the building and pest inspection shows the property's in good condition, what's the difference? Not a lot. You'll have a 1300 number to call, you might have to get your way through a receptionist to get to them, not a big difference. But if the slightest thing goes wrong, or you've got a question on the definition of a term, or the applicability of a clause, or how a high court or Supreme Court case changes the definition of a contract, your paralegal is going to be woefully untrained and inadequate. They're not going to understand those things. Most of them have a checkbox, they follow through a checklist, anything outside that checklist, and you're going to very quickly notice the difference between a conveyancer and a solicitor. And the price difference is very small between law firms that have conveyancers and solicitors, and then it can be as little as $100 difference. And what I say to clients is that $100 can be extraordinarily expensive when the slightest thing goes wrong.
And you're right, if all things go well, then there's no issue, but you're not engaging someone if all things go well. Yeah. If you have a nasty vendor that starts playing up, you need someone to act on your behalf. That's what I've found in my experience.
Yeah, that's right. And also just being able to bounce ideas off a solicitor. So a lot of the time, particularly if you're a first home buyer, your parents have told you about things when they bought a property, your friends have told you about things, and if you try and come at a conveyancer with all of these different questions, quite often they're just not going to know because they just weren't trained in it, and all they've done is they've followed their checklist, and often what they'll say to you is, I'll get back to you, and what they're going to do, they're going to go ask the supervising solicitor.
Yeah.
So that's the big difference.
A few clients have asked me, what does fixed fee conveyancing mean?
Okay, so in Queensland, if you call any law firm and you ask for a quote on conveyancing, they're all going to quote you a fixed fee. Now, what a fixed fee is, often with solicitors, they'll charge based off the time it takes in 6-minute increments, etc., etc. Fixed fee means this is the price for the entire project at hand, in this case, a sale or a purchase of a property. But it's really important to ask them, is that a fixed fee for the total conveyance or a fixed fee for a standard conveyance? They might say, well, what's the difference? Well, a lot of law firms are, because if you don't quote a fixed fee in conveyancing as a law firm, you're not going to get any work because every single law firm quotes fixed fee. So
people want to know what they're up for.
Exactly.
At the end of the day.
Exactly right. So you're not going to find one law firm does a fixed fee and the other one does it on a time basis, so you choose a fixed fee. Everyone's going to quote fixed fee. The difference is most law firms, most of them, will quote a fixed fee for a standard conveyance. And what that means is, you know, there's one issue with building and pest and they'll deal with it for you. Or you need one more week to get your finance approval, or another couple of days to get your settlement in order. That they'll do as part of the fixed fee. As soon as you want a second extension, or there's 5 building and pest issues, they start adding $30 here, $50 there, until your bill often can be double. Even though you've been quoted a fixed fee, you've actually incurred all these additional costs. So the difference with us, we have a fixed fee for the total conveyance. So whether it goes...
How many times you've got to go back and forth?
That's right. And you know, some conveyances go extremely smoothly, others are quite turbulent. But for me, I think it's important, if you're quoting a fixed fee, people nowadays, solicitors think they're clever with standard conveyance or total conveyance. Solicitors are known for trying to weasel their way out with terms and conditions and standard wordings. I take it from a basic human perspective. If you quoted a fixed fee, you expect that that is the only fee. It's been fixed, right? So that's the way I've approached my business. I didn't want to come into the point where it was, you know, I'd quote a fixed fee, I'd add on $50 here and $100 there, and then clients start accusing me, quite rightly, of charging more, and then I'm having to justify, you know, or explain away things when I know what I've done. I couldn't do that.
Tom, that probably what you just said about fixed price conveyancing leads on to, obviously there's search costs on top of that. Now there's a multitude of searches out there that you can do. It's very confusing because quite often clients ring me when they've got the solicitor's paperwork in front of them and they scratch their head and they go, which searches am I supposed to do? And you start looking through the list. I said, well, how much do you want to spend? Personally, I've always just done the mandatory ones or the basic ones. Maybe you can shed some light onto why you do searches and what are the required ones for most people to do?
Sure. So the important thing to bear in mind is there's a principle in Queensland of buyers beware. Now what that means is, following settlement, you as the new owner of the property inherit most of the debts and liabilities that attach to the land. So what does that mean? Well, for example, if your seller hasn't paid their council rates and they're $1,500 in arrears, after settlement, you as the new owner of the property inherit that $1,500 debt and you've got no further rights against the seller. So what we do is, most clients don't want to do the searches until they know they can purchase the property. They've got their finance approval because they don't want to incur the cost of searches on a property that they can't afford to buy. That's fair enough. So we know they're going to buy the property, they've done their building and pest, they've done their finance, now we do the searches. We're looking for important things, particularly hidden costs that could be for the client after settlement. So for example, we do a rates and water search, make sure those have been paid. We do a survey plan search, so that checks for easements, encumbrances, making sure there's no encroachments, that the plan of the lot is what has been disclosed to them, that it's the size that's been disclosed to them. We do a land tax search, because if you own a certain amount of non-residential land in Queensland, you have to pay an additional tax called land tax that's levied against the actual lot. So you could be paying someone else's land tax if you don't do this search.
So you inherit the land tax as well?
Exactly right, because the land tax attaches to the lot, it doesn't attach to the person.
Wow, okay.
So in order to discharge it off your title, you'll have to pay it.
And the land tax can be quite big.
Yes, yes, it can be.
Absolutely.
So the reason why we do searches is because you're rolling the dice. If you don't do the search, you're hoping that the seller has no issues with the survey plan and has paid all of their rates and water and land tax, which is not always the case.
A massive assumption.
You would be surprised how many sellers, particularly at the end of the period, on the Gold Coast here, rates are levied semi-annually, so between 1 January to 30 June, 1 July to 31 December. At the moment, our rates notices are coming out. You'd be surprised how many sellers who have got their property on the market right now are saying, why would I pay my $900 rates notice? I'm going to be settling in 30 days, I'll pay it from the sale proceeds. Particularly these sorts of times of year, people, or when they list the property, they think no more money out of pocket, it'll be paid from sale proceeds. But if we do the search, which is what I always recommend my clients do, and we discover that there's an outstanding debt, there's a clause in the contract that compels the seller to pay it at settlement. So we find there's $1,500 in unpaid rates, they must pay the $1,500 from their sale proceeds.
So it basically comes off the purchase price. Yeah.
Well, it comes from their sale proceeds.
Yeah. I think there's another interesting thing that I, to be quite honest, only found out very recently, and that is when you actually sign a contract to purchase a property and there's an agreement and the selling party have agreed to the terms, that actually from that point in time you are liable for the insurance of that property even though you haven't settled. Is that correct?
Yeah, essentially. So look, there's a standard term in the contract that says that the risk in the property passes to the buyer at 5 p.m. on the business day after the contract date. So what does that mean in English? If you sign a contract today on Thursday, at 5:01 p.m. on Friday, that house burns down, you as the buyer must rebuild that home.
Even though you haven't bought it yet?
You don't own it, it's still subject to finance, it's still subject to building and pest, your purchase is still subject to your sale property settling. You are responsible for rebuilding that property.
Crazy.
Because the risk in the property, in fact, I've had a case where I was acting for the seller in this case, where there was hailstorms up in North Queensland, completely smashed through the carport and damaged all the windows and everything. The buyer had to pay to fix my seller's property because the risk in the property passes to the buyer. So you think, how do we mitigate against that? Well, the first thing I say to my clients is to take out insurance. Most insurers in Queensland will offer an insurance policy. They won't charge a premium for 30 days. And so if anything happens to go wrong with the property between you signing and the contract and the settlement date, the insurer will cover the costs. But it's really important. Very few people know this. And there's some buyers that will hesitate to take out the insurance for whatever reason, even though there's no premium, because they're getting overwhelmed or there's other things. But it's really important. Because you are liable. It's as clear as it can be.
But the seller, they still have an active insurance policy, right?
And here's what the first question I get from sellers when I advise them about this term. They go, "Oh, the risk in the property is passed to the buyer. Does that mean I can cancel my insurance now?" And my advice is no. Firstly, because the buyer may not have taken out insurance, and so if your house burns down, you go after the buyer because they're responsible for rebuilding the property. They don't have insurance. You can sue them all you want, but if they don't have the money, they don't have the money.
Exactly.
Or the buyer could have taken out insurance, but it's inadequate insurance. It's not enough to cover the bill, because at the end of the day, they're insuring against their own risk. So if you're a seller, even though the risk in the property passes to the buyer, it's important that you maintain your house insurance until settlement happens.
How about if it happens and the buyer pulls out under finance or building and pest? They don't have that liability anymore?
That's correct. So as soon as the contract's at an end, all of the buyer's obligations under the contract, including their obligation, the risk in the property passing to them, ceases. So again, if you're a seller and you've cancelled your insurance and 7 days into the contract, your building and pest is done and the buyer terminates, you've now got a property that's uninsured and you're going to have to take out insurance again.
And they may forget to reinsure it.
Yeah, well, that's right.
Shouldn't cancel it till it's gone.
That's right.
Isn't that another exact reason or very critical reason why you should use someone who knows what they're doing, who's a solicitor?
Exactly, and that's what I was saying when we were talking earlier about why to engage a solicitor, because there is over 15 pages of 2-column terms and conditions, and that one is clause 8.1. I know it from memory because it's an extraordinarily important clause. Yeah. Now, if you as a buyer are just perusing through that contract, or you're relying on what the real estate agents told you who may have forgot to mention it, or you're relying on the advice of friends, it's unlikely they've come across that.
No, never rely on friends for advice.
Hey Tom, Marco from Mackay here. Thank you for your wisdom. I was wondering, there's the question in regards of building and pest control clauses in the contract. They can be a little bit of a grey area sometimes. In reality, if there is something wrong, can the buyers terminate the contract?
Maybe. So what the clause says is that the contract is subject to the buyer getting a building and pest inspection report that is satisfactory to them, acting reasonably. So what does acting reasonably mean? Well, there's been a Supreme Court case that's ruled on that term. This is again what I was saying, conveyancers are probably unaware of the Supreme Court case and what it says. Supreme Court case said this: if the property had aesthetic issues, the paint's not as good or there's a creaky door, then they're not acting reasonably to terminate. If the property is structurally unsound, there's a safety hazard, there's structural damage to the property, or there's extensive pests in the property, and you terminate, you are acting reasonably. Everything in between is grey.
Yeah.
So what it comes down to is it comes to a debate between the buyer solicitor and the seller solicitor about is the buyer acting reasonably, which is again why it's important to have a solicitor in your corner rather than a paralegal, because we're trained on how to negotiate, we're trained on how to read a set of facts or read a set of matters or analyse a building and pest report and pick out the right things that we can argue about. Because sometimes as well, buyers change their mind.
Yes.
And after the cooling off period's over, you've only got building and pest or maybe finance to be able to get out of the contract. And so it's important to have someone who's in your corner who can negotiate using the building and pest condition as a means of terminating. So you have to act reasonably. Most times there's common issues that can concern first home buyers particularly because they haven't seen it before. Most properties have drummy tiles. Most properties have air conditioners. The excess water isn't connected to a drain. Most properties will have hairline cracks in the driveway. All these things, for a first home buyer, it can actually be quite confronting because you get a 30-page report of all the things that are wrong with the property, but often they're surface level or aesthetic because of the nature of what the building inspector's role is.
Most of the 30 pages are disclaimers, aren't they?
15 of them.
I couldn't do the furniture, I couldn't do this, but quite often I've seen people negotiate, it might be $5,000 towards those repairs, or the vendor has to fix certain things to keep the contract alive. But you're right, if it was just a paralegal, quite often they'll just go back to the client saying, oh, no, they said no to your request.
Exactly right. And that's a good point. If there's something, because you get it in the report and it's not satisfactory to you, you don't have to terminate. We can start negotiating with the seller, either a price reduction or you can get the seller to engage a certain professional to go out and fix it to your satisfaction and provide evidence of it being fixed. So you've got a lot of rights in relation to building and pest. So can you terminate if there's an issue? Probably, if you've got the right person in your corner. But you can also use your solicitor to negotiate with the seller so that whatever's unsatisfactory in the report is fixed for you.
Obviously, disclaimer, this is not personal financial advice, just general in nature. If you want anything detailed, feel free to contact our office and we give you a personalised assessment.